Hi folks, in a prior video I talked about substantial aggravation of a pre-existing condition. In this video I'm going to talk about a case, a 10th district case in 2014. It was actually a bench trial which discussed the requirements, specifically the fact that you don't need pre-injury medical or diagnostics for a pre-existing condition. And that might sound kind of weird, but essentially, let's say you had a right knee injury, and let's say prior to that right knee injury you actually had osteoarthritis developing in your right knee, but because it didn't cause any issues for you, there was no pain, there was no limitations to that due to the osteoarthritis, you didn't know that you had osteoarthritis, you have your work injury. That work injury is said to have substantially aggravated the pre-existing osteoarthritis, and then you're trying to get that condition added to your claim so that you could either get injections or possibly get some type of surgery. So in Ohio, again, you're not required to prove that you had the condition by pre-injury medical or diagnostics, but what you are required to do is you are required to show that the work injury, or the condition rather, pre-existed the work injury and was substantially aggravated by the work injury. And that might sound kind of weird, but essentially what you need is a medical provider to review the post-injury diagnostics and clinical exam findings and the examinations that they undertook, and essentially opine, looking at this post-injury x-ray or MRI or whatever, based upon what I'm seeing here, clearly this shows that the condition pre-existed, and I could tell that it pre-existed because there's bone spurs or whatever, and it would take a number of years to develop bone spurs, and also it shows that it's substantially aggravated because it got worse, or the range of motion findings diminished over time. So in this case, the Strickler versus City of Columbus, this person was trying to get chondral fractures of the right knee and then substantial aggravation of pre-existing osteoarthritis of the right knee. So it was a bench trial. What a bench trial means is that it's just heard before a judge. Typically with workers' comp cases, 512 appeals, you want to have, if you're the plaintiff, you want to have a jury because you want the jury to hear the facts and decide the facts. Jury might be more amenable to and sympathetic to an injured worker versus maybe just a judge sitting and deciding both facts and law. So that's why you might want to have a jury. Why this person didn't have a jury, who knows? It's possible that the jury demand or deposit wasn't filed in time. You're required to, in Franklin County at least, I think it's 30 or more days, I believe, that you have to file what's called the jury deposit. It's about $300. And if you don't file that jury deposit in time, the judge may very well say, okay, you don't get a jury. Or the opposing counsel might object, and the judge might go along with what they want to do. So nevertheless, this was bench trial. The judge allowed the individual the right to participate for the chondral fracture of the right knee, but denied the claim for the substantial aggravation of the pre-existing condition. And where this person failed, or where their case failed, was their expert, and I guess their expert was named Dr. Van Stein. When he was deposed, all he said was, hey, this person has osteoarthritis. He did not state why this person has osteoarthritis. He didn't go to any diagnostics and say, oh, that diagnostic clearly shows that this was pre-existing. And the only evidence establishing a possible explanation came from the plaintiff, which your plaintiff, you can't testify as a medical expert. I mean, you can't do that anyways. You're not an expert, and osteoarthritis is not a common knowledge injury, but nevertheless, testified that her May 11, 2007 MRI scan showed osteoarthritis in her right knee, and she was told it just can't appear overnight. So I had to have had it before April 18, 2007. And then they go on to say, this plaintiff failed to identify who provided this explanation to her, so we cannot attribute it to the doctor, Dr. Van Stein. So as a plaintiff, you can't just say, oh, this doctor said that I had XYZ condition. And frankly, even if she knew that it was Dr. Van Stein, that wouldn't be sufficient. Dr. Van Stein has to opine in a deposition, this MRI from May 11, 2007, showed the arthritis or whatever. And they give examples of where this is done correctly. And this one case, this is called Brate versus Rolls-Royce. And I guess this is a 2012 case. And what they go on to say is this: the claimant's treating physician testified during post-injury arthroscopy of the claimant's right knee, he observed arthritic changes that, due to the advanced pathology, pre-existed the claimant's incident. And then in the Fifth District, so that's the one who heard that case, held that this testimony, along with expert testimony that the workplace accident worsened the claimant's osteoarthritis, was sufficient to overcome the employer's motion for summary judgment. So the employer filed a motion for summary judgment. This is what's a pre-trial motion, and so you're trying to get the case booted out, before it goes to trial. And so they draft this thing called a motion for summary judgment, and the plaintiff would have to file a contra motion. And basically, the motion, if the court were to grant that motion, essentially it's stating that this person loses because the facts cannot be analyzed in any other way but the way that we're presenting. So a lot of times you'll see employers file motion for summary judgments in these substantial aggravation cases, and most of the time they're rejected because it's one of those things. If there's evidence, sufficient evidence, then a judge is going to say, I want the jury to look at this and consider the doctor's testimony and all the evidence, and I want the jury to determine. I don't want to sit here and make a decision. They gave another example, Bowl versus Cassens, and in that case, this person had, the treating physician pointed, so this person had an x-ray and they were trying to get cervical degenerative disc disease, and so the treating physician pointed the bone spurs, again there's the bone spurs, visible in the claimant's post-injury x-rays and MRI scans, and testified they took years to develop and were present before the injury. And the Third District Court of Appeals relied on this testimony along with the physician's opinion that substantial aggravation had occurred and the declining results of range of motion tests to conclude that the claimant had proven a substantial aggravation of pre-existing condition. So that's essentially, again, what this case, this decision is stating in the Strickler case is, again, you need a medical expert. You don't need pre-injury diagnostics or medical, but you do need a medical expert to relate how the post-injury evidence shows pre-existed and shows that it substantially aggravated, the work injury substantially aggravated that same pre-existing condition. And it has to be objective medical evidence. It just can't be complaints of pain. So you can't just, you're not going to win. It's going to be, that will be summary judgmented out if you have no evidence, but before I didn't have any pain and now I have pain. So the substantial aggravation requires objective medical evidence, and again, that could be diagnostics, orthopedic tests, clinical exam findings like range of motion tests and findings and things like that. But that's what the Strickler case discusses. I may discuss some other substantial aggravation cases because there's a large body case law around this particular area. But again, that's how that case went forward, and unfortunately this person did not prevail because she didn't have sufficient medical evidence. As I stated at the end of all these videos, workers' compensation law in Ohio is particularly complicated and labyrinthine. I strongly urge you, if you have workers' comp injury, even if things are going great, reach out to an attorney or two or three or four. Ask your coworkers, your friends, relatives, your primary care physician, anybody, if they have any referrals or recommendations, but call a workers' comp attorney, run your situation fact pattern by them, and they might suggest that you get representation. Otherwise, they'll say, hey, you're doing fine, you don't need it. So you've been listening to Attorney Kip from Malik & Malik. Thank you, and stay safe.